Good afternoon, ladies and gentlemen. My name is Dirk Dirksen. I'm pleased to be the Master of Ceremonies for today's People with Disability Foundation seminar entitled Healthcare Issues for People with Psychiatric or Developmental Disabilities in Hospital with emphasis on assessment and referral issues. The Peoples with Disabilities Foundation was created in March 2000 with a mission of total integration of people with mental, physical, or mental and physical impairments in combination into the whole of society. This is the sixth in a series of public awareness seminars. People with Disability Foundation's Executive Director, Stephen Bruce, has spent the past 2 decades being an advocate for those with disabilities. He is admitted to practice before the U.S. Supreme Court, the United States Court of Appeals, several U.S. District Court and state courts. As of today, parity does not exist between people with mental impairments and people with physical impairments. It is the purpose of today's seminar to focus on healthcare for people with mental and developmental disabilities in an attempt to further the rights of these individuals to live independently, to build self-esteem, and to generally have the same healthcare opportunities as with all other people. Triage, assessment, and referral is often the first step in obtaining appropriate medical treatment. The People with Disability Foundation is honored to have a panel of experts. Lauren A. Johnson, MD, is Chief Medical Officer of Sutter Emergency Medical Associates, Incorporated, Sacramento, California, and Medical Director of Emergency Department, Sutter Davis Hospital, Davis, California. He also serves as the President of Health Access Associates, Incorporated, a consulting firm specializing in EMS regulatory compliance. Dr. Johnson is past president of the California chapter of the American College of Emergency Physicians. He believes that emergency care is an essential public service. Bernard Sklar is board certified in psychiatry and family medicine. And finally, Pam Cohen, a mental health attorney with Protection and Advocacy, a federally funded organization located in Oakland, California. Pam has lectured at Columbia and Stanford University and has published numerous articles. At this time, it's my pleasure to turn over the microphone to Stephen Bruce.
Thank you, Mr. Dirksen. Pam Cohen, Dirk Dirksen mentioned some historical laws, the Rehabilitation Act of 1973, the ADA of 1990. Could you give us sort of a current status of the law as it relates to equality in programs and services for health care with respect to the population we're talking about, meaning people with psychiatric disabilities?
I think what I'd like to do is give an outline sort of what I think the legal issues are in this area. And then the doctors can fill in their perspectives on it. And then if anyone has a question about the legal aspects of it, they can ask one of us. The other handouts that I brought are, neither of them PAI wrote, but this is by the Foundation for Taxpayer and Consumer Rights. It's called the California Patient's Guide. And it's more extensive than just emergency room medicine, but I think it's a really good, clear summary of very clearly written of what your rights are in the health system in general. And there are sections in here that directly relate to things I'm going to talk about, like informed consent and emergency room medicine. And then this is the Department of Mental Health's patients' rights, rights for individuals in mental health facilities. That's what it's called, but it applies to people with psychiatric disabilities wherever they're treated, not just in mental health facilities. And I don't usually go around giving out government documents, but this one in particular, I think is really a good one.
Is that state or federal?
This is
The
state.
last
This is
state.
California. So the first, and then I also have an outline of what I'm saying here. That's on green paper. Just to really quickly run down, I'm talking about legal rights. What kind of legal rights am I talking about? Where do they come from? It's important to remember that before you even talk about statutory rights, and you'll hear about EMTALA and HIPAA and the ADA, remember that there's the constitutions above them. And we have state and federal constitutions that give everyone the right to liberty and the right not to have that, right taken away without due process of law. And also, there's a constitutional right to privacy. They're not real specific to emergency medicine, but it's important to remember when we're talking about statutes and cases that all the statutory and case law has to be compliant with these larger grants of rights which are under the constitutions. Statutes and regulations fall into two categories, federal ones and state ones. Federal statutes are implemented by federal regulations, and state statutes are implemented by state regulations. Some of the federal laws that you'll be hearing us talk about are the Emergency Medical Treatment and Active Labor Act, that's EMTALA, the ADA, the Americans with Disabilities Act, and the Health Insurance Portability and Accountability Act, which is HIPAA, and you'll hear more about those later. And then the state laws are a combination of all kinds of licensing laws that apply to hospitals and skilled nursing facilities, where a hospital or a skilled nursing facility can't be licensed unless it does X, Y, and Z. That's where a lot of your state rights come from. There are also more specific rights, particularly when it comes to psychiatric patients, sort of a Psychiatric Patient's Bill of Rights that says specifically psychiatric patients have the right to freedom from seclusion and restraint and all kinds of things like that. So I'm going to talk a little bit about that too. So when we're talking about emergency room medicine for people with psychiatric disabilities, we have to realize that we're talking about a combination of laws affecting everyone who goes to an emergency room or wherever you're getting emergency care, and then also rights that are specific to people who are receiving psychiatric treatment. And that's LPS. If anyone's heard about the Lanterman-Petrus Short Act, the LPS Act, that's the act that protects people with psychiatric disabilities in the state of California. Usually when we talk about that, we're talking about the rights of people who are institutionalized, or we're talking about conservatorships, but it also applies in other settings. And then there's case law, which interprets all the other kinds of laws that I've been telling you about. And then it's important to remember, too, that you have a contract with whoever your insurance company is. And that insurance company has a contract with the hospital, and the hospital has a contract with the doctor. So underneath all of this are these contractual obligations, and increasingly with HMOs and managed care, the contractual rights are becoming more of an issue. But it's also important to remember that your constitutional and your statutory rights come before your contractual rights. So you can't waive a constitutional right through a contract, even if they try to. But a lot of the details about what you're entitled to, especially in terms of relief, will be dictated by the terms of an HMO contract or a PPO contract or something. I could have organized this in various different ways. The way I conceptualize it is the rights that are relevant in the situation of a person with a psychiatric or developmental disability coming into an emergency department fall roughly within these areas. One is the right to treatment, access to treatment. And then the other is the right to refuse treatment, which involves issues of informed consent and capacity and competence to make decisions. And then the other area is the right to privacy. And there's a lot in there, but I think it's kind of easy to conceptualize it in those three ways. Under the right to treatment, the important thing is that EMTALA, the federal law that covers emergency care, requires that all hospitals that participate in the Medicare program, that's virtually all hospitals, have to care for all persons regardless of their personal characteristics or regardless of their ability to pay. And when I mean regardless of personal characteristics, I mean regardless of sex, national origin, race, and disability. So you can't be denied care in an emergency room at all within the guidelines of what EMTALA says is the care that's required to be provided. And the care that's required to be provided is screening, stabilization, and transfer. So EMTALA requires that emergency rooms screen everyone to see if there's an emergency. Labor, by the way, is always an emergency. To stabilize the situation so that it's no longer an emergency, no longer life-threatening, and if that hospital can't provide the services the person needs, to transfer that person without delay. And the nature or extent of an individual's mental or physical disability cannot affect the way that the hospital discharges that obligation. Okay? Now, the ADA would also require that of hospitals, because the ADA requires that all public facilities provide care regardless of the disability. Is there a question? Can you bring the microphone? But EMTALA is much broader in this area than the ADA. What the ADA does is, that adds to that, is to make sure that hospitals are physically accessible to people with physical disabilities and also accessible to people with mental disabilities, in that if someone comes in with a psychiatric disability and is having trouble understanding what's going on, there are accommodations that the hospital has to provide under the ADA because of the person's psychiatric disability. Is there a question back there?
Okay, I heard you mention about without race, without gender, or for psychiatric service. But right now, California is having this issue about illegal immigration. So I'm just curious, we see a lot of immigrants who, may be seeking, and my question is, where do they fall under?
It's a very good question. That's included. You do not have to be a legal resident. You do not have to be a citizen. It applies to all people. But remember that this is only for screening, stabilization, and transfer. Okay? So it's a broad act in that it covers everybody, but it's narrow in that it only covers you while your life is in danger. Okay? The obligation of the hospital to care for you after the emergency is over is another story.
So I'm under the impression, from what you just said, that if someone has an emergency, goes into a facility, and because of mental problems, and does not understand what's happening to him, you're saying that they have to provide someone to help that person understand. I don't understand how that works.
That's the next part of my talk, actually.
I was going to ask that too,
Yeah.
because a conservatorship or guardianship proceeding is something which could take quite a while to institute, assuming
Well-
the person doesn't already have someone else to give consent.
Right. Conservatorship and guardianship is different, and that's not really what I was referring to. What I really meant was, if someone comes in very agitated, and here's an example. All right, here's an example. Someone comes in and is carrying a little dog, and that dog is that person's companion, and that person gets very anxious without the dog. This is not far-fetched. It happens all the time. And the intake nurse takes the dog away because dogs aren't allowed. And the individual becomes more agitated when they don't have the dog. Now, that's a situation where the hospital, even if it's not a service dog, the hospital may have to find a way to allow at least the initial interview to happen with the dog. Seriously, because that's true if you rent an apartment and there's a no pets policy, that has to be waived if you have an emotional need, a real actual psychiatric disorder that requires you to have the dog, and that would be the same. The ADA would require that. Now, reasonable accommodations have to be reasonable, and no, he can't go to the operating room with you, but that's the kind of thing I'm talking about. But that does also have to do with informed consent, which is the next thing I want to talk about in terms of, yes, okay, so EMTALA allows you access to treatment, but what if there's a question about whether you're going to want treatment and what kind of treatment you're going to want? Informed consent is the right to accept or refuse treatment, has to be exercised after the patient gets clear, understandable information about the risks and benefits and alternative treatments, okay? There's this exception called the simple and common exception if it's something that it has such low-level risk that everyone knows, like if you take a blood test, there's really hardly any risk to it. There's not much you have to do with that. The right to informed consent belongs to the patient as long as the patient is capable of exercising it. Now, the issue is what if the person isn't capable, or if there's a question about that. First of all, make sure you understand what capacity is and what competency is, or competence. I'm not sure which one's grammatically correct, even though I work in this area. Capacity is your actual ability to understand and make a decision, a particular decision about a particular thing, because everyone's capacity to make various different types of decisions, it depends on the decision. There are a lot of decisions that I'm not capable of making, and a lot that I am. Competence or competency is your legal ability to make decision. That's a legal judgment, okay? They're both situational, like I said, meaning you may be competent to make healthcare decisions at one moment and not competent in another. You may be competent to make healthcare decisions, but you may not be competent to make financial decisions, okay? And most importantly, capacity and competency are presumed under the law. You're presumed to be capable and competent to make a decision unless the law shows otherwise, okay? Now, if you're conserved, the terms of either an LPS, a mental health conservatorship, or a probate conservatorship, either one, your right to make healthcare decisions for yourself will depend on the terms of the conservatorship. Even on LPS conservatorships, the conservatorship will say, yes, this individual can make certain kinds of healthcare decisions, or no, they can't. So just because someone's conserved doesn't necessarily mean they don't have the legal competency to make decisions. So when we're talking about emergency medicine, the question is, obviously, let's say someone comes in, they appear to be incompetent to make a decision. There's no guardian or we don't have guardians in California. There's no conservator anywhere. We don't know if there is one or not. The person's not communicating. What do? The doctor has to make a reasonable effort to locate someone who, preferably, first of all, to find out if there's a conservator. Because if there is a conservator, that's the person you want to talk to before you talk to anyone else. It doesn't matter who the person comes in with. If the person comes in with Aunt Sally, but Aunt Jenny is the conservator, you need to find Aunt Jenny, okay? As long as the conservator has the power to make healthcare decisions, or you think that might be the case. If there's no evidence of any conservatorship, then the doctor has to make a reasonable effort to find a family member or a friend or someone who can speak for the person. That reasonable effort is construed, it's reasonable. It's like all these legal definitions.
Excuse me, Pam. It seems to me it must be, by definition, a function of the nature of the emergency, the extent to which someone's going to do a search for the patient who, for the purpose of my question, has very diminished capacity.
Mm-hmm.
So let's assume that they can't do any kind of reasonable search because the person is more than incoherent, but on the other hand, it looks like it would be unproductive. What is the next step, or have they satisfied that obligation?
Well, the question is what's reasonable under the circumstances.
Right.
It's always reasonable to send the nurse out to the waiting room and say, hey, anyone know Joe? Okay, there's no circumstance where you can't do that. And then the extent to which you go beyond that depends on what happens when you ask that question and how dire the emergency is. Assuming you need to do something really fast, then you do it. Consent to life-saving treatment is presumed if someone can't speak for themselves. So the doctor can do what the doctor needs to do to stabilize the emergency situation and no more. So if there's in an emergency, there's often sort of what you need to do right away, and then there's all kinds of things you want to do after that. You have to wait until the emergency stabilizes, see if the person regains competency, and then try to get informed consent for the next step. The doctor can't go beyond what's necessary to stabilize the person and get rid of the emergency.
What if the hospital has a chart which shows, it's episodic, which is not unusual, and the person does have a history of being in the psych ward within the last 6 months or so? Is it pretty safe to rely on that, even though it's concrete in writing and signed by a doctor, but it's
No.
in the past?
No, you can't. That's what's sometimes called the frequent flyer problem.
Uh-huh.
People who repeatedly end up in emergency rooms, and unfortunately, it happens all the time. And no, it doesn't matter how often someone has seen this individual before. This person may be living in the, just outside the lobby of the, sleeping on the ground outside the hospital and showing up all the time. It doesn't matter. You assess competence at the moment of the emergency. And you can't, the only thing, if you were going to a court hearing to determine competency, the person's history would be relevant. But in terms of making an assessment right then, no.
As a practical matter,
It happens all the time.
yeah, I was just thinking, that's the way it's supposed to be done, but
that's
as a practical matter, they're going to say, oh, well, Joe, he's been here 50 times, it's the same story, we'll just...
Well, that's my prerogative in being the lawyer on the panel,
Yeah.
is I get to tell you what should happen, and these
May I
guys
ask
can
a
tell you what really
question?
happens.
Yes, Dr. Sklar.
Yes, I wonder if you could distinguish between a psychiatric patient with a medical emergency and a psychiatric patient with a psychiatric emergency, and how that's different, how you approach that differently.
Yeah, and I was just going to get to that, actually. Have you been reading my outline? That's another issue when it comes to the right to refuse treatment, broadly defined, is what happens if 5150 is the statute of the Welfare and Institutions Code in California that allows a hold for involuntary commitment for people when they have when there's a question about a psychiatric disability. If someone is having a psychiatric emergency, that person would be shifted into the 5150 process and held. And I don't want to go into all the details right now about sort of what the legal requirements are, but I do want you to know what the standards are for a 5150 hold, because it's these short holds that get to longer holds that end up often in conservatorships. And there's due process rights to representation, and there's rights to hearings all the way through that process. But the very first one is what they call a 5150 when they take someone into a psychiatric emergency room. The standard for a 5150 hold is that someone have a psychiatric disorder, and that person poses an immediate threat to him or herself or other people, is dangerous to him or herself or someone else, or is gravely disabled. And gravely disabled is defined as someone who can't take care of their needs for food, clothing, and shelter.
In some other states, the number 3, they don't have. Like Florida has Baker Act. It's in all states, I guess, that's something similar. I mean, you're dangerous to yourself or others. I know when I was doing those Baker Act or here 5150 Act hearings many months ago, there were people who didn't take their medications, and therefore within the 3 days often it was resolved. But the gravely disabled is an area which it's not totally clear to me exactly how that's applied.
I think constitutionally, grave disability has to be virtually identical to dangerous to yourself. Okay? And that's why a lot of states have done away with the grave disability standard, because what grave disability can't be is simple refusal to take your medication. And I've represented people in conservatorship hearings where the judge says you're going to be conserved because you're not medication compliant. Well, that's not enough. You need to show that the person's refusal to take medication is going to result in is reasonably certain to result in harm to that person. And so...
so how is it used then, if it's almost synonymous with danger?
Because it makes people feel better to know that we can that we can commit people who are not maybe right this minute dangerous to themselves, but because they can't take care of themselves, will very quickly become dangerous to themselves. That's really, I think, how it operates in practice. What it operates in practice, unfortunately, I think, is to allow for a lot of inappropriate commitments.
Yeah, I was going to ask if you saw abuse in that
I
area.
do see abuse in that area. I do.
I
I do,
wonder
because I don't think
could-
judges understand it.
Can I ask you to follow up on my question? I was thinking, for example, somebody who is psychotic and, say, hearing voices and has a major gash in the leg and is bleeding 20 cc a minute or 50 cc a minute, doesn't want the doctor to sew up the leg because he believes that this leg wound is there for a reason. What is done with that person?
That person will be committed. That person will be 5150'd. And in the process of being 5150, the leg will be sewn up. But that really is it's both, what you're talking about is something that has both a psychiatric emergency and a physical emergency
Right.
at the same time.
Right.
And what's likely to happen, depending on how fast the person's bleeding, if the person really is bleeding like that, they'll sew up the wound. And that's, I'm not going to say that's not appropriate. The real issue is what happens after the 5150 proceedings are commenced, and once that emergency is stabilized. We don't know in that situation the extent to which the leg wound is contributing to the delusions until we've stabilized the leg wound. Yep.
It seems to me that one of the main problems here is that MDs are not qualified to evaluate psychological disabilities. Can you comment upon that?
Well, psychiatrists are MDs. So
I think he means
you mean emergency room doctors. Well, I think probably Dr. Sklar is better
Well,
qualified, or Dr. Johnson, or
Doctor
both.
is going to talk a lot about that, I assume.
Should we
At least
save that
that'll be
for,
part
do you
of
want
the
to go
talk.
back and forth? I don't.
Well, that is going to come up later, but let me ask something along the line of Timothy's question, Pam. Finding a treating psychiatrist, or the chart, let me use the analogy of looking for a conservator, would seem to me to be extremely important.
Finding a
Is it
doctor to do
the
what?
doctor who's familiar with the patient's psychiatric diagnosis, the treating source, the treating psychiatrist, psychologist, or psychotherapist, is the obligation to find that individual as strict or as the one you described with the consent issue in finding or using best efforts to locate a conservator?
The requirement, when you're talking about getting informed consent, the requirement that the doctor find someone to speak for the patient, is that what
Right.
you're talking about? It
Yeah.
doesn't matter. You want to find the person who's best able to speak for that individual within the confines of the emergency. So the emergency is always going to dictate how fast you have to work and
Right.
the extent to which you have to work.
So there's no legal requirement in terms of finding the person who would know the patient the best in terms of their mental status.
It's a reasonableness requirement. So if the person walks in and says, "I'm Joe and my conservator is Ann and this is her phone number," then you obviously have to call. If Joe has given his wallet to the nurse and there's a card in there that says, "My conservator's name is so-and-so," you have to call. But I can't, you can never define these things. This is why there's case law on this, because it's all going to depend on the particular facts of the particular situation. But obviously, if you know who the conservator is, that's the person to call. If there's a family member who's accompanying the individual, that may be the person to talk to.
Let's assume there's no conservator. There isn't any. And there's a psychiatric, as Dr. Sklar said, let's stick to the same thing. He's having auditory hallucinations, and he's clearly psychotic. Is there any legal obligation to locate the treating mental health provider, the psychologist, psychiatrist, the psychotherapist, to find out?
I would say there is, within the confines of reasonableness.
Okay.
So I would say, yes, there's definitely an obligation to try to find that person.
Okay. And
You're not necessarily going to be able to find that person in the time that it takes to stabilize the patient. So,
okay. All right, thank you.
yeah, I mean, you have to do the best you can. Yeah,
I'm curious, you've talked a lot about psychiatric disabilities, but
Mhm.
I'm actually much more interested in the idea of the developmental disabilities. So can you
Okay.
address that?
Yeah, everything I said applies to both. It's all about what I've talked about so far has to do with access and capacity. And you can have capacity issues because of a psychiatric disability or a developmental disability. The way that the situation works in practice may be a little different. Psychiatric disabilities, I think, you can correct me if this is a misstatement, but they tend to be less predictable in terms of coming and going and situational. If someone has a developmental disability and isn't able to understand because of a developmental disability, it may be that that's going to be pervasive from one day to the next. I think in terms of the way that there's some differences in the way that doctors and nurses can interact with people depending on why it is they're having trouble understanding. But the legal issues apply across the board.
So if I can ask, if there is someone developmentally disabled, it could result in less overall attention, whether it be by the nursing staff or even the CNNs. It's easier to converse and also get information and to treat someone who does not have an IQ, I'll just say 50 in my example. Is this a problem that you see in any cases, that is a difference in the attention or quality of care using developmentally disabled?
Okay, my perspective on this is a little bit, I've never represented people with developmental disabilities. The legal advocacy world is really split that way. I work with people who do. But and I've worked in agencies a lot where we represent both. My understanding is that obviously if a patient is having a problem, it's a huge problem, regardless of what the disability is. But we see it less, I think, with developmental disabilities, just because people with developmental disabilities statistically are more likely to have people coming in with them and helping them. And that, of course, not always. But there's such a, because of the, I would say, greater stigma attached to psychiatric disabilities, and because of the much more pervasive revolving door problem where people are in and out of care, and because of the way that psychiatric disabilities tend to get acute really fast and then come down, and this emergency room issue, I just see it more as a mental health lawyer than my colleagues who are developmental disabilities see it.
This is a general question. I mean, let's say there's, someone goes to you because there's been problems in some of these areas. Do you use the Health and Human Services Office for Civil Rights? Do you use any state agencies? Do you use state or federal courts? And is there a preference, and why?
It would really depend on what the issue was, and a lot of these areas I wouldn't handle at all because there'd be medical malpractice issues. Most of the relief that I'm talking for problems that happen in this would be medical malpractice, and we don't take medical malpractice cases at all because they're fee generating, and we can send them out to private lawyers. So the extent to which I actually represent people in emergency room cases would just be giving them advice, because if someone had a bona fide, someone might call me and say the emergency room did this, and I would try to tell them, well, I think you may have an action, or I think you may not have an action, and if they have an action, I refer them to a tort lawyer. So let me just see where I am in my outline here. This is important. Under the emergency exception we were talking about to informed consent, a doctor cannot provide treatment if he knows or if he has reason to know that the patient has exercised an advance directive, meaning a durable power of attorney or a declaration under the Healthcare and Natural or Natural Death Act. And now anyone who's hasn't been living in a cave during the Terry Schiavo era knows what an advance directive is, and it just points out the importance of writing down what you would want to happen to you in an emergency, because that is the most important right that you have, is that document.
Pam, with advanced directives, the issue has come up that it seems like people who are developmentally disabled and to an extent have mental illness tend to have there's a higher percentage of them with advanced directives. Statistically, do you have any enlightening,
It may be
news about-
because there are advocates out there like us who say, get an advance directive. And it may be because there's going to be people who have any kind of disability are more sensitive about their health and the possibility that they may be in an emergency situation. And people with disabilities are very sensitive to the possibility of other people making decisions on their behalf. So that doesn't surprise me at all. The rest of us think we're, immortal and nothing's ever going to happen to us. The issue that comes up, which I thought you were going to ask, is does someone have capacity to make an advance directive? And
I think that was really the underlying thought in this
That's really
question, with the
complicated.
do not resuscitate orders.
that is really
Right.
complicated. PAI is still working on what our position is on that. I think there is, I think what I can say is that you can be significantly developmentally or psychiatrically disabled and still know that you do or do not want life support, and still know that this is the individual who you want making decisions for you if you're ever in a situation where you can't give consent. So just like any kind of capacity, you can look at an individual situation and you see what it is this individual really is capable of expressing at that moment, and you write it down. And it may be less than what you or I can write down, but at least it's something.
Yeah, I wanted to ask a question along those lines. I mean, I have bipolar disorder, and if I'm just like somewhat depressed and then I fill out, a do not resuscitate, and then, how is that, who determines that that's legal? Or
Well, who will determine it ultimately is probably the doctor in real, in actual fact. Whether in reality, the thing to do is to make sure that you go over that advance directive over time, because especially for something like bipolar disorder, where you can be in different stages, you want to make sure that this advance directive is reflecting,
A longitude.
yeah, where you are over time. So you should just know that about yourself. And I would say good advice would be to get somebody to help you with it and make sure that there's someone else coming to you over time and saying, is this really, is this still what you want? Advanced directives are very fuzzy things. I mean, everyone knows that it's hardly ever a situation where an advance directive covers exactly the situation that's going to come up, because you just can't anticipate everything. And all of us have good days and bad days anyway. And also just the idea of writing an advance directive puts you in a certain state of mind. So really, it's just better than not having anything. And durable powers of attorney are a way around that. If there's anyone in your life that you trust, that person will know the exact situation that you're in at the time, and that may be, depending on who's in your life that you trust, that may be a better way to go, or a combination of the two. But I think our other speakers are going to want to talk about that more. I think the only other point I wanted to make is 2 points. One is about realize that the capacity to refuse psychotropic medication is separately covered under the law. And if a conservatorship, someone who's under conservatorship retains the right to refuse psychotropic medication unless the judge specifically makes a determination that that person does not have that capacity. And it has to be a separate hearing. You may have heard of Reese hearings. That's for the Reese case. And a Reese hearing is a separate proceeding where the judge has to determine that the person not only should be conserved, but also is not able to make their own decisions about psychotropic medication. Judges get this wrong all the time. It's a really big problem, and public defenders don't understand it.
Could you just repeat that last statement you made about?
If someone's conserved, a lot of people think that once you're in an LPS or a mental health conservatorship, that conservator can decide when you get shot up with Haldol and when you don't. And that's not true. There has to be a separate determination that you lack the capacity to refuse to accept or refuse, make informed consent about psychotropic medication. Just like the right to vote. You retain the right to vote when you're conserved. People don't know that either, unless the judge specifically says you lose the right to vote. There are certain specific rights that we make sure are
What are
specifically
the time parameters on this? I mean, say someone is LPS or 5150, and this is before any conservatorship hearing is going to take place. Then is there no right to refuse medication?
Well, there's an
in the
emergency
interim?
exception. There's an emergency exception in the 5150 process too, which is similar, that you can force psychotropic medication only to the extent that you need to prevent serious harm to self or others.
And how long, let me just say, and how long can this go on for? I mean, there's 72 hours and 2 weeks. I mean, in terms of getting, assuming the person is not in a conservatorship, that this process may take a while.
There are patients' rights advocates. This is another thing I want to make sure everyone knows. If you're in there's some dispute in different counties as to the extent of the coverage of patients' rights advocates. They're always in the psychiatric hospitals. I have an argument with Alameda County right now about whether they should be in the skilled nursing facility. My position is that under law, the county hospitals should all have patients' rights advocates representing there to help anyone with a psychiatric disability, regardless of why they're in the hospital or which hospital they're in, but that's not always the way it works. Those patients' rights advocates are in charge of helping people who are in these kinds of situations where there's a 5150, the person's violent and aggressive, there's a decision made that they need a shot of something to calm them down. Then that emergency is over when that patient's stabilized. If that person's starting to come off the medication and gets violent again, that's emergency number 2. In the meantime, and it doesn't often happen that there's there's a need for another emergency, or there is another emergency, but in the interim, there should be a red flag that this is somebody who may have a competency issue, and the patient's rights advocate should be coming up and saying, this person has the right to refuse, and there should be a capacity hearing. If the hospital wants to continue to involuntarily medicate someone, they need to file for a capacity hearing.
And can you give any guidance? I mean, is there any guidance in terms of 2 weeks or 30 days? I mean,
There isn't really guidance on that. It depends. I mean, if the person's involuntarily held, involuntarily held. The time for which they're involuntarily held is separate from the extent to which they pose an emergency situation. You know what I mean? They're in there for a psychiatric. They're in there for a They're being held for a psychiatric emergency.
Is there danger to themselves
Right,
or others?
But once they're in the hospital and they're medicated, then you need to see what happens. It may be that they don't need to continue with that particular kind of medication.
Right.
The person, well, actually, one thing I should say to back up a little is that nobody can be involuntarily treated until they've refused voluntary treatment. And that's something that people forget too. So once assuming that a policeman finds someone on the street that they're concerned about and they say, so do you want to come to John George? And they say, are you out of your mind? Then that's an involuntary commitment because the person said, no, I don't want to come with you voluntarily. But it may be that once that person's stabilized and the person says, look, and the doctor or someone says, look, now that you're here, we can continue with this involuntary treatment or we can voluntarily treat you. The person does have to be given the choice to be there voluntarily.
I just have one short comment on that. Isn't that the scenario in the now famous Supreme Court Olmsted case where the 2 women in Georgia
it was voluntary initially, and they stayed for 3 years.
Oh, my client, I'm thinking of, the client I spend most of my time with has been voluntary at a county hospital for 30 years. Because, and then they've tried to repeatedly to commit her, even though she's already in the system, for the sole purpose of involuntarily medicating her. And I've had to come up and say, look, she completely has capacity. She has as much capacity to make informed consent as I do. But she's a behavior issue, and they don't want to deal with her behaviors, and so they have to initiate involuntary commitment proceedings in order to establish that she lacks capacity, even though the involuntary commitment proceeding just keeps her in the same medical center that she's already been in voluntarily. A lot of people are there voluntarily because they don't have any place else to go. For financial reasons, if you're looking at a county hospital.
Oh, you mean a warm meal and a bed?
Well,
and
no,
a shower?
no. I mean, I'm talking about the client I'm thinking of in a wheelchair with primarily physical, but also some psychiatric disabilities, who just simply
Caretaking reasons.
doesn't have. Yeah, I mean, she could certainly live independently with a full-time caretaker. They just, there isn't. We're working on that, but.
Yeah, well, that issue, that issue, which gets into the Olmstead issues, is going on in all 50 states, all of which are out of compliance.
Well, that's one of my issue. That's one of my pet issues, actually. But yeah, we need the mic, I think.
Thank
Oh,
you.
you have it.
I am a consumer, and I am coming out of the closet to say, yes, I do have a psychiatric disorder, and I'm not court-ordered to do anything, but I am now, doing all my programs and doing research. I am also a client of the Department of Rehab. And one of the things I've learned about the Department of Rehab is that they have their advocacy program called CAP, which is a state program and one of my fears about this mental health Prop 63, each county has their own internal, what was the word, patient rights advocate. And I've had problems in Alameda County where the behavioral health care system, they're on the payroll to defend the practice of whatever complaints consumers may have. And I feel it's a conflict of interest. And I really, I'll get on my knees, I'll stand on my head, but I really think the PAI, which needs to get aggressively involved with Prop 63, because we're going to, many patients, like my many patients, clients, will be impacted again by practices which they segregate us based on race, gender. If you're not Native American, you can't come here. If you're not Latino, there's so much segregation in the mental health programs in this county. And I just feel it. So I, as a veteran, also, I go to the VA, and I do have Medi-Cal and Medicare, but I'm still not authorized to receive services through the city services because I'm a veteran. And most of us veterans don't qualify for psychiatric services in the VA or dental services, so I'm falling through the cracks here. So that's basically, I'd like to hopefully wish your organization could really come forward and be like an advocacy rather than trusting this responsibility.
Let me say something about that in terms of PAI's perspective on that. You raise a lot of really important issues that are kind of, most of them are far afield from emergency room medicine, so I'll try to address PAI's take on Proposition 63 and patients' rights advocates, both of which are important issues. Prop 63, we are so involved with Prop 63. I just actually yesterday became the person in my office who's now going to be really heavily involved in it, so I have a lot of reading up to do. But we have committees. Does everyone know what Prop 63 is? Prop 63 is the initiative that authorized a tax of incomes over $1 million, a tax only on the over $1 million part, to be spent on services, mental health services. It's now, after it passed, it's called the Mental Health Services Act. There's lots of the state has guidelines for how that money can and cannot be used. The counties have plans that have to be compliant with those guidelines. We are watching like hawks what the counties are doing. With that, our biggest concern, and this has nothing to do with emergency room medicine, is that not be used for involuntary treatment, that money not be used for involuntary treatment. But I don't want to go into that in detail. The patients' rights advocates, I work very closely with them, and you're right, there is a wide range of what they do and how well they do it. I admire them greatly. They have a really difficult job, and they are, like our agency, underfunded and understaffed. And so they have helped me tremendously in being able to go in and get records for my clients. They're actually the ones who do the retention hearings when somebody's committed. By and large, they've been very good about letting me and my colleagues come in and offer them legal backup when things get complicated. But they don't have enough resources to do their job. And so, so it's not, I don't know that there's so much a conflict of interest, because I think I can say that at least the Bay Area, there's a Bay Area consortium of patients' rights advocates that I work with, and I really do think, they really do have the patient's interests in mind. The question is how far they can stretch themselves to do what they need to do. I mean, there is the issue of privacy. HIPAA covers, provides that you have a confidential relationship with your doctor and that they will not disclose information without your consent, except for under certain, exceptions. And I'll let the doctors go into that in more detail. But